Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shameika Rhymes, and today we're talking about what happens when fault is clear, but the defense argues the accident did not actually cause the injuries being claimed. Welcome back, Kiernan.
Thanks for having me, Shameika.
So, Kiernan, why do some injury cases become heavily disputed even after the defense admits fault for the accident?
Think about trial like a credibility contest. The fewer losing points you argue, the better that you generally do. Sometimes clients want to fight everything like it's warfare, but ultimately fighting over everything is a lot like fighting over nothing. And smart defense lawyers know that. There's kind of an irony to this when we talk about stipulated cases, which is what lawyers will call this, where they stipulate to liability, meaning they admit liability and aren't going to contest it at trial, which is that there's something that I like to call a BS tax, which is how much the jury holds it against you when you make arguments that are BS. The defense pays a much lighter BS tax than plaintiff lawyers typically do because we brought the case and we have the burden of proof. So they kind of expect us to have it together when it comes to what we're arguing. But I don't know if it's because of a comparison to like criminal defense lawyers, but defense lawyers' clients are there involuntarily, and juries understand that it's the defense lawyer's job to make arguments to help their client, even if those arguments aren't very good. So they pay a lighter BS tax, but they're also incentivized to argue about less if they can. Like a plaintiff's case is like a stool. You don't need to knock out all three legs. You can just knock out one and it's going to fall down. So sometimes the smart move for the defense lawyer is to argue about less and pay less of a BS tax, arguing points they won't win by viewing the case as ultimately about credibility. They can kind of try to conserve some credibility by paring down arguments, especially ones that they don't think that they're favored to win.
What are the most common arguments that defense attorneys use when they try to challenge injury causation?
Preexisting conditions. Preexisting condition is essentially an automatic defense that we're very likely to face in virtually every case in some form. Cases where it doesn't happen are very rare. Like, for example, I just settled a $1.25 million case last week without filing a lawsuit. And in that case, my client had a emergency neck fusion surgery in the hospital after being admitted after the crash within 24 hours. So it'd be really hard for them to ever argue that surgery was necessitated by a pre-existing condition. But in most cases where you don't have an immediate emergency surgery like that, like burn cases, it's hard to argue somebody has like pre-existing face disfigurement because of burns. But in a lot of cases that deal with things like chronic neck and back pain or, TBI cases that involve, chronic mental health or cognitive impairment problems, they will default to arguing that those are pre-existing, at least to some degree.
So is that even when they get medical records and see that there's nothing in there that says that, will they still try to argue pre-existing?
Oh, yeah. I've had defense counsel through their experts argue that an 18-year-old had a pre-existing disc herniation in their neck caused by aging. So, yes, they will argue this. It's completely generic. Like, we see it every time, pretty much.
So why do pre-existing conditions become such a major issue when injury causation is disputed?
Because it doesn't need any specific evidence to make the argument, right? Like most cases that are, crash cases or fall cases, the objective test for the injury at issue is an MRI. And an MRI shows the condition of somebody's like spinal discs, but it doesn't show the cause. And discs will wear with age. Like as people get older, the discs will dehydrate and they'll start to lose some structural integrity. And once people are over the age of 70, typically they'll lose a little bit of height because their discs will compress. So just naturally, by going about your business day to day through life, your discs will eventually become compromised at some point. So they'll blame aging. They'll just say that this disc problem wasn't caused by the incident. It was caused by normal wear and tear and like disease of life. And ultimately what they're doing is they're pointing at the limits of MRI technology. MRIs show us what somebody's discs look like. They don't show us how they got that way. So as long as that continues to be true, they will always be able to say, well, that's what their discs look like anyway already. And there usually aren't prior MRIs to show what the discs look like. So they'll just argue it. And it's an easy argument for any defense expert to make based on nothing in particular other than the limits of what MRIs show.
So, why do imaging studies sometimes become that major battleground when the defense argues that the injuries existed before the accident? Let's say there is you know, after the accident, you get the MRI, but before maybe there is an x ray or something. Of course, that's not going to show the same thing.
Yeah, I mean, well, first of all, X-rays are very important to bring up because X-rays show the condition of the bones, right? So it's like X-rays will show you whether you have a fracture. X-rays typically will not show the condition of the disc. You need an MRI to show that. Same with CTs. CTs are just like high-res X-rays. They don't show what's going on with the soft tissue. They show what's going on with the bones. And most of the time when somebody sustains a herniated disc, they don't have a fracture. So, it, X-rays are generally pretty useless unless you're dealing with a fracture. So the MRI shows what soft tissue looks like. Again, not how it got that way. And I kind of answered this question with the last one, which means I'm anticipating your questions, which just tells you how often this comes up. It is a very, 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 very common issue to have to argue about in a case. It's such a common defense. So, you know, over 50% of people over 50 have herniations with zero symptoms. There's studies that have been done on this. It's like just because you have a herniated disc does not mean that you have any symptoms from it. In fact, it's more likely that you don't have symptoms. So, I've never had an MRI of my spine before. I could very well have a herniation at one or more levels, and I don't know about it because it's never caused me a problem. So I've never gone into a doctor, so I've never had an MRI. But like causation of injuries doesn't just come from like an MRI. I mean, the MRI shows what's causing the pain specifically, but without the pain, there's no reason to do the MRI. So causation is often as much about when pain and dysfunction started, not just, the anatomical cause of it. You do the anatomical cause analysis with the MRI to figure out what treatment needs to be done. But, without pain, without symptoms, there isn't really an injury to speak of. So the MRI tells you this is what's causing the pain. The disc is herniating and compressing a nerve, and that's where the pain's coming from. But it doesn't tell you what caused it. And unless there's edema, like a lot of blood or an adjacent fracture that shows up on the MRI doesn't tell you what caused it. So that's why it's always just essentially a freebie for them to say, well, what if they already had this problem? But they didn't already have the pain. So
So, how do defense experts try to separate the accident itself from that medical treatment that someone later receives?
a lot of different ways. I can only hope to adequately skim the surface of it. But one of them is it didn't happen. They're not really hurt. They're just after money. The whole thing is cooked up by plaintiff lawyers and greedy plaintiffs and crooked doctors. We see that. They're already hurt. They'll blame pre-existing injuries, even if there's no medical records that show pre-existing injuries, and just say this person was already like this. Oftentimes with the MRI, with the radiologist, it says this was caused by aging, not by trauma, when in reality, the MRI can't tell you if it was caused by aging or trauma. And we have to look at, symptoms and presentation to the doctors to decide how it happened. They'll also re-diagnose people. They'll say, the treaters said that the person had a disc herniation with radiculopathy, that they suffered acutely as a result of the incident, and the expert says they had a soft tissue sprain or strain that the body should heal within 4 to 12 weeks. So they'll just re-diagnose the person and say they have different injuries than what was actually discovered by the doctors. They'll also just grade the homework. This is like the negation defense, where they won't even say what the person has or say what the person needs. They'll just look at what was done and say that it should have been done differently. Like the person had an MRI before they had had 3 months of therapy, then they shouldn't have done the MRI. They had an injection before they had 3 months of therapy, they shouldn't have done the injection. They had a medial branch block, they should have done an epidural steroid injection. It's just sort of saying no to whatever was done rather than formulating an opinion about like what's actually really going on here. How hurt are they? What do they need? Uh, Price is another big one. The doctors billed X, they should have billed Y. Y is always less. Sometimes doctors are charging a lot. Sometimes doctors are charging too much. Doesn't mean the plaintiff doesn't owe the money, but they'll quibble about what the bills should be. It's a very common area of dispute. And future medical, like future is always uncertain. What's going to happen in the future? We don't know. You don't have a crystal ball, right, expert? So they'll fight about futures, and they rarely feel like they look foolish doing so unless somebody is in a wheelchair or something like that. So they can always kind of argue that somebody doesn't need something that their doctor said that they did.
Can delayed symptoms make it harder to prove that an injury was caused by the accident in the first place?
I would say yes, and it feels like this issue carries more weight with juries than it really should. Everybody knows people will sometimes skip going to the doctor. Like, for example, I microfractured my left foot when I was running in 2021, and I waited 4 days to go to the doctor. I had to be convinced to go to the doctor because I thought it was just a sprain. I walked in kind of sheepishly, like, gee whiz, I shouldn't even be here, but I'm just coming here to get it checked out. And the doctor's like, yep, you've got a microfracture on your foot. So just because you've sustained some kind of injury doesn't mean that you're going to immediately rush to the first doctor that you could possibly find in order to document that you've got a problem. There's people that are just doctor avoiders. Sometimes, like folks that played a lot of sports, like are used to playing hurt, and they just don't go to the doctor every time. Upper respiratory infections are a great example. Some people go in right now because it could be bacterial, and they don't want to wait 7 days before they get prescribed antibiotics if it is bacterial, and other folks will just wait out the viral infection and then only go into the doctor if it hasn't gotten better by the time a viral infection would have improved. Like everybody kind of knows this, and we're dealing with this all the time, but the gaps in treatment hand the defense an opening to question whether the injury was ever really real in the first place. And it feels like they get more mileage from it than they really should, because we all know from our daily lives that, like, just because you're in pain or suffering discomfort from an illness or an injury does not necessarily mean that you must automatically go to the doctor. Like, sometimes things go undiagnosed for quite some time. So it does matter, and it feels like it matters more than it should.
So, why do prior medical records sometimes become the most heavily contested evidence in these cases?
Because of the pre-existing injury defense. Another reason is that in the United States, the second most common reason somebody goes to a primary care doctor is for lower back pain. The primary number one reason why people go is for upper respiratory infection. But a lot of the time people will have gone to the doctor before for a back issue. A lot of people, once they get to a certain age, maybe their back has gone out once or twice. But if somebody's asked in a deposition, if you've ever been to the doctor before for back pain, they might say no because they don't remember it because it happened one time. And then all of a sudden, those records all go get subpoenaed, and then the plaintiff is tried to be made to look like they're being dishonest or hiding something from the jury. But in Texas, if a prior injury was asymptomatic at the time of the incident, the judge is going to instruct the jury not to subtract any money from the verdict based on this asymptomatic pre-existing condition. I'm paraphrasing the jury's instructions, but that's the general gist of it. And also, another thing is, like, some injuries compound. Like, the fact that you've had a prior traumatic brain injury actually makes it more likely that if you have another traumatic brain injury that you will get a worse outcome from it. It's exponential. So, like, repeat injuries make it worse and worse and worse. So, having a pre-existing TBI makes present TBI claim more compelling, not less. But, a lot of folks have kind of been programmed to treat pre-existing condition as like a valid discount, and it usually isn't, unless somebody had the same problems before the incident that they have after the incident. A less than perfect body or less than perfect medical history isn't a valid defense, in my opinion. And that's what we have to go to court to fight about sometimes.
And to wrap up, what usually ends up deciding cases where the accident itself is clear, but the injuries are still being heavily disputed?
Two things: the credibility of the plaintiff and the mechanism of the injury. And I would even personally lean more towards the mechanism of the injury. Mechanism of the injury meaning, was it a car wreck? Was it a trip and fall, slip and fall? If it's a car wreck, how bad was the car wreck? Things like that can be proven by physical evidence. Vehicle damage photographs, the plant went boom and sent a shockwave. No, and the reason why I think mechanism is often kind of the linchpin of these disputed injury cases is that nobody has to believe anybody. The jury can see it for themselves. Like if you hear that somebody fell 3 stories from a building or had a light fixture fall on their head, you're automatically getting certain images in your mind about how hurt the person could be. And if there's a fender bender, you're getting other images in your head about how hurt a person could be. And, if somebody has to sit through a 1-week, 2-week trial and listen to a ton of witnesses and experts who, these folks over here are saying one thing, those folks over there are saying the complete opposite, it can start to feel like noise to juries, and physical evidence kind of cuts through the noise. Severe damage photographs make an injury more fundamentally believable than, photographs that show barely detectable property damage. Sometimes it is unfair and doesn't make sense because often it does happen where people can get hurt very badly in relatively minor car crashes, and I've seen extreme car crashes where nobody was hurt or people sustained only minor injuries. But generally speaking, that like the jury's perception of how believable the mechanism of injury is at causing the harm that is claimed is, I think, a big factor in whether or not juries ultimately buy into the plaintiff's case. And when a mechanism is a little bit less conclusive, it often comes down to the gut check of, do we believe the plaintiff? It happens, all the time, where the credibility of the plaintiff's testimony, how well the plaintiff does, how supported the plaintiff's testimony is by friends, family, and other relatives who know them, who can testify on their behalf, and how well the experts do. Those all kind of support the overall picture of how credible the plaintiff is. And I think that is another really big factor to consider.
Kiernan, as always, for breaking this down for us. This has been super informative.
Thank you. Of course.
Well, that wraps up this episode of Limits Exhausted, Texas Injury Litigation Podcast with Kiernan McAlpine of McAlpine Law Firm. If you're dealing with a serious injury case involving complex litigation issues, visit McAlpineLaw.com to learn more. And be sure to leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.